welcome to today's webinar. We're going to give everybody just a couple of seconds to file into the session, and we will get started here.
I like that you still have a picture of Florida, Isaac. I think you might have reused this graphic.
Well, I'm going to blame it on my marketing team, but I'm also going to blame it on Florida for starting some of this mess. So there's plenty of blame to go around. Not any to assign to me, though, of course.
That's right. Well done. Trying to get it so you guys can see the background of the big atmospheric river that's hitting Southern California right now. We call it atmospheric river. It's really like an inch of rain.
Oh, well, we had heavy rain here. I'm in Phoenix. For those of you listening into our weather talk, I'm in Phoenix, where it's always perfect and beautiful. But we had an unusually heavy amount of rain over the last couple of weeks. So I'm glad it's back in the 70s, which is what we should expect for the next couple of months. Well, I see we've got the numbers starting to slow down with the number of people coming in. So we'll go ahead and get started. For those of you who are coming in, I will give everybody a warning real quick before I jump into the introduction. Have your cell phone ready and your camera specifically for a QR code that's going to come up in a moment here. But I'll get to that in a second. Good morning or afternoon, depending on where everybody is. My name is Isaac Schloss, and I'm the Chief Product Officer at Contact Center Compliance. A lot of you may know us as DNC.com. For those of you who don't know who we are, we partner with our customers in helping you comply with the various regulations regarding customer or member outreach. So this might include scrubbing against the state and federal do not call list, reassignment, flagging, weeding out known professional plaintiffs through our litigator scrub product. We also have this fantastic regulatory guide that helps you stay up to date with the ever-changing regulations that are out there that affect our industry. We also help with call deliverability, so getting errant spam tags removed, branding caller IDs are all a big part of what we do. Now, a quick housekeeping note before we jump into this: we do have a Q&A tab where viewers can post questions or comments. We encourage you to do this. This is going to be a great opportunity to ask questions about the topic we're discussing here. We'll do everything we can to address your questions during this webinar, but if we don't get to any, and oftentimes we don't have time to get to them all, we will follow up afterwards as long as you signed in with an email address. If you joined anonymously, we will not be able to get back to you on this. And finally, while our speakers are often attorneys, as is the case here, every business is very different, and the information shared here should not be taken as legal advice. We do recommend that any changes to policy be reviewed with your compliance team, with qualified counsel, and if you don't have a good attorney that specializes in the type of regulations we'll be talking about today, I know a couple that I can definitely recommend to you. So with all of that said, I am very pleased to be joined today by Eric Troutman, better known as the Czar, and Pooja Amin, better known as Queenie, from Troutman Amin. Very easy to remember their names based on the firm name. And they're going to be discussing a piece of legislation that Eric broke, Monday, I want to say, through his TCPA World publication. If you do not subscribe to that, you need to go to tcpaworld.com and sign up immediately for the latest regulatory news. But this reminds me, if you're looking at my screen here, and this is what we started talking about, the Florida legislation that came up in 2020, 2021, somewhere in that area. It was SB 1120. It's rare I remember a bill several years later, but it completely rocked the world of the calling industry in a very bad way. So this to me seems like that, but at a much graver level, just because of how impactful this could be to our business. So I asked you all to have your phones ready. Hopefully you do by now. I did promise in one of my LinkedIn posts, we've got this QR code. If you scan this, there is a summit that we're going to be hosting for DNC.com right here in Scottsdale, Arizona. You can use this code. This offer is only good for today. You can get $50 off. We don't have a ton of tickets left, so I recommend you sign up as quickly as possible, and I will try to bring that up again towards the end. But for now, I'm going to take the focus away from the summit, and I'm going to put the focus on the content here. And Eric, I'd like to start with you. You want to give everybody just kind of a quick overview of what the heck we're seeing here?
Yeah, so first, hi everybody. Tons going on right now in TCPA world, as I think you all know. I think, Isaac, at some point we should just touch the FCC's one-to-one rule, which was just published on Friday, the new implementation deadline, which is January 27, 2025, the proposed notice of proposed rulemaking comment period for small business is now triggered, right? That's February 26th. And then in addition, still looking at FCC developments, they had the new FCC rule around revocation, which totally changes the revocation game. We are aware of all these developments, folks. We cover them, of course, on TCPA World, and we will talk about some of them. But this webinar was specifically designed to talk about the new bill that Pallone has sponsored. And it's actually an omnibus bill that is available on TCPA World. It's actually going to be 5 different bills that have all been kind of rolled in together. The Pallone piece is actually the robocall piece, which we're going to talk about. But there are several other massive changes coming down the pipe here. And I got to tell you, we are pretty plugged in over there in Congress. I knew some of this was coming. Some of this I am surprised by. But what I'm hearing right now is this is going to have some legs. I always try to tell you guys if it's going to go or if it's not going to go. I think I've got pretty much a perfect record. This one, what I'm hearing is it's got legs. Now, that doesn't mean it's going to go all the way. It doesn't mean it's going to become law. But I do not expect this one to peter out the way that a lot of these have petered out. So we've got to start taking this one very seriously, kind of right out of the gate, which is why here we are on this webinar. So there's quite a few pieces to this. We're going to break them into more detail here, break it down in more detail. And forgive me, I've got a bit of a cold today, so I'm not going to be as vibrant as you usually. But that's why we have Pooja here, to be more vibrant. So the first big piece, right, we're going to break this down and get into more detail. I'm just going to give you a quick overview, is we're going to get rid of the definition of automatic telephone dialing system completely. Just this thing that we've been fighting over for 30 years, we're just going to pull that definition out, throw it in the garbage can. Instead, we're going to have a new definition, something called a robocall. Now, remember, the last 6 months, I've been talking about the fact that there's no federal definition of a robocall. And you all have to remember this, right? Congressional staffers, Senate staffers, FCC, FTC, everybody follows me. They read my blogs. They hear what I say. So I think somebody was like, oh yeah, there's no definition of robocall. The czar is right. Maybe we should create one of those, which, by the way, I did not tell them to do that. They did that on their own, but I think they got the idea from me. So there's going to be, for the first time ever, a federal definition of the word robocall. We're going to talk about what that definition entails, but it's going to replace automatic telephone dialing system completely. And as we're going to find out, it's going to really broaden out the scope of the TCPA if this rule is adopted. As Isaac just said, there are shades of Florida here. So that's one piece of this. We'll talk about this in more detail, I promise. We're just kind of touching it at a high level first. Second piece, though, very important. Those of you that use AI, generative AI, 2 big changes coming. First, it'll be the first ever restriction ever on the use of cloning AI, meaning AI that's going to use somebody else's voice to communicate for the purpose of fraud. That would be the first ever regulation that's going to be found both in the TCPA and the TSR if this portion of the bill passes, and I think that it will. Not a bad rule, in my opinion. We'll talk about it, but I think that's a good thing. Y'all should not be using generative voices for fraudulent purposes. I think this law is good, and I'm glad it's going to be on the books. Next piece, though, which is interesting. I think I'm a little agnostic on it, but definitely, again, big news. The first ever at the state or federal level, first ever requirement of disclosure that AI is being used to communicate with a person is going to be modified into the TSR, meaning any generative or non-generative AI that's being utilized for pre-recorded or artificial voice, which they all are, right? And to any consumer for marketing purposes, at the beginning of that message, the AI is going to have to say, hey, this is so-and-so, your AI, whatever. So for those of you that had big dreams, and I know many of you do, of using generative AI to communicate with consumers, that's cool. It's basically still going to be allowed. It's not like it's being banned, as long as you have the right level of consent. And of course, we know the FCC has just come down with Jessica Rosenworcel, the chairwoman, just yesterday issuing a statement confirming that what we already knew, which is generative AI is an artificial or pre-recorded voice message under the TCPA. This bill will align with that and determine that for FTC purposes under the TSR, any pre-recorded voice, any artificial voice, any generative AI is going to qualify as a pre-recorded voice under the TSR, and it's going to require additionally that disclosure. First time ever, really, really big deal. We've been waiting for this to see where the first disclosure requirement was going to come from, and wouldn't you know it, it came from the TSR. A few other pieces to the bill. We'll break them all down, but I just want to give you that high-level overview. That's kind of what we're talking about today. Hopefully that answered the question.
And then one more, Eric, that I'm going to add is it redefines the definition of telephone solicitation to include any text or call that is transmitted to a person for the purpose of deception, fraud, or wrongfully obtaining anything of value.
In addition to the regular definition of telephone solicitation.
Correct.
See, and then I didn't even mention, I'm telling you, I'm slow today. I'm definitely getting sick. The definition of text message. For the first time ever, the TCPA will be expanded to expressly include text messages. Now, we know the TCPA already applies to text messages because the courts have so found, but there's an incredibly broad definition of the phrase text message that's being added to the statute. And it's so broad that basically any form of communication that's done over your phone is going to constitute a text message, unless it's a real-time voice and video communication. So if you like to use one of these apps like a Snapchat or a TikTok or a, what the heck is that, the Marco Polos, right? And as you can tell, I don't use any of these. But apparently, like, these are all going to constitute text messages. WhatsApp, going to constitute a text message, right? So really fascinating. It's a pretty big change because I know, again, many people were looking to get away from SMS platforms, going to OTT services for communications, hoping and dreaming that maybe the TCPA wouldn't apply to them. Well, if this new bill comes forward, and it looks like it might, all this is going to be covered by the statute now. So pretty big change.
Well, over here in the Silicon Valley industry, we're all hip and cool and use all the Snapagram, WhatsApp, chat, TikTok things. So, very scary for everybody that's involved with that. And that's, I think, a good place to start, because on your guys' website, you posted, this was in one of the TCPA World postings this week, a red line where you took the proposal as it exists today. And obviously the proposal as it exists today, even if this does pass, isn't necessarily word for word what it's going to look like whenever it's voted on, whenever it gets passed. So something for everybody to keep in mind. This is a developing story. You'll get updates, as soon as we do. But the red line is great, and this is another thing that really reminded me of Florida. I remember when Florida happened, the way the bill was originally written, it was little excerpts here and there. So there was like 4 or 5 bills all at the same time that were proposing similar things. The one that passed had the least language in it, and just at a quick glance, it read like, oh, everybody's going to be exempt from this. But when you laid it in line with the actual statute as it existed in Florida, it got very scary. So seeing this red line that Eric's bringing up right now, I think really helps drive home the difference of this. And the first thing that jumped out at me is, and Eric already mentioned this, they struck the definition of an ATDS, but then you go down just a couple of lines and they reference an ATDS, and they talk about how it, right there where you've got the mouse. So is this, if this were to go through as it exists today, would this create some sort of debate over what an ATDS is?
If it goes forward the way it is today, it is nuts. So let me just say, there's no way it's going to go exactly the way it's written now. The staffers that are behind this, I am 1,000,000% sure, have already picked up what I'm writing on TCPA World. This is like, you cannot take a defined term like automatic telephone dialing system, strike it, and then embed it into a definition without any other definition. It's crazy. They won't do that. I don't know exactly where this is going to land, because truthfully, I don't know what they were thinking. And I'm not saying this in an insulting way. I'm saying I literally don't know what they were trying to accomplish by striking and then re-adding without any further definition. It is conceivable that they're trying to basically preserve the status quo, right? A system that would be an ATDS today would still be an ATDS tomorrow, but then add additional pieces on top of it. But that's not what they've done here. So I mean, the truth is, I don't know what they're trying to do. If it goes forward the way it is right now, it would just be a mess. It would create just endless litigation. But what else is new, right? It's TCPA World.
Well, see, that's where, right where your mouse is, there's that little word "or" in the line just below it. And that's a big part of what made Florida so difficult, was that word "or." Now, it was in a slightly different usage, but it was anything that automatically selected or generated phone numbers, as I recall from the language. So that or statement here, I look at what this defines a robocall or the equipment behind a robocall, and it talks about any system that can store a phone number or that randomly or sequentially generates those phone numbers. So this becomes problematic, I believe, because, and you've talked about this before, the significant human intervention they talk about. Everything stores a phone number. Salesforce stores a phone number, and I don't think anybody would consider Salesforce a dialer. You might integrate your dialer with Salesforce, but Salesforce can store numbers. Does that become a dialer under this definition?
Yeah, and Pooja, feel free to jump in here. But look, the way I interpret this, as it is currently written, is any system that stores numbers and then integrates with anything else that calls numbers is a robocall. That includes this. That includes every CRM that integrates with any telephony in America. That includes anything. The only limitation on what is a robocall, which again is going to be any call, okay? The only limitation is found here at section B, which says, right, the term robocall does not include a call made or text message sent using equipment that requires substantial human intervention to make or send the call. Now, what this is likely trying to do, right, is say essentially any manual call is not a robocall, which makes sense. But look at the words that they use. Does not include a call made or text message sent using equipment that requires substantial human intervention. Think about your phone, right? If I pick it up and I call, well, I'm using substantial human intervention. But does this equipment require human intervention to make a call? Of course not. Put an app on this and blast 1 million people, right? So the way they've written this, these are non-lawyers writing these things. We elect non-lawyers to Congress all the time, and their staffers don't know what the heck they're doing. I say this with love. I say this with love, not that much love because I'm pissed. The way this is written, right? Basically, only highly specifically designed solutions, right? Like Safe Select. Congratulations, right? That is equipment that requires substantial human intervention, but like 99.9% of dialing apparatus do not require that, even if you use that day to day, because that's just how you pick up your phone and call, right? So, you use Salesforce, any telephony system, any phone system these days that's going to be a soft phone. None of those require you use just day to day, but you could easily modify, right? Any software is going to be modifiable. Any software could be used in a way that does not require human intervention. So you've got this whole capacity issue, you've got this requirement issue, you've got this whole thing that we saw in 2015, right? It's back again. It's back in live. And again, this is not what Congress is trying to do. Congress is not trying to create this mess. They're just not thinking this stuff through. The way, obviously, the folks that have litigated thousands of these cases as we have, we know exactly where this is going to go in the courts. Like, we've seen this before.
But even if the language were changed in some fashion where instead of it saying the equipment requires substantial human intervention, well, it says it requires it to send or receive calls. So would a click to dial even be considered substantial human intervention, or are they trying to close that gap where they say, no, we want you to have to dial half of the numbers, half of the digits, or all 10 digits, or something like that? I mean, what is there even a precedent for substantial human intervention?
And there's a whole nother issue, right? So issue one is everything's a robocall unless it requires substantial human intervention. Even if we leap that, even if we get an understanding, that no, we mean like presently, today, as configured, whatever, then the question becomes, well, what the heck is substantial human intervention, right? And no, there's no case law around that. So that'll be, the first set of case law will be if you are using, LiveVox HCI and there's a clicker agent going like this as fast as they can, right? Is that substantial human intervention? What constitutes substantial in this context? There's no case law. Now, that means it's going to be in the eye of the beholder of the judge. And we've seen this before, right? Some judges are going to look at a click-to-dial system and say, well, I mean, that's substantial. It couldn't have happened without the human being. Therefore, it's substantial. In fact, some judges might even go further and say, well, hey, the human being had to choose what numbers are in the account, are on the campaign. They had to load the campaign. They had to set the parameters and the timing. They had to click the button. That's substantial, right? Other judges are going to be like, that, you're crazy. That's just turning on the light switch to get the program on. That doesn't count. You know, clicking to dial, that's not substantial. The human being's not doing anything. The human being has to be making a decision. The human being has to be using, you know, human thought and selecting what number to call next. You know,
Right.
Who knows what these judges are going to come up with? And it's going to be a split of authority, and it's going to be a disaster. Now, again, I am confident that this language will be changed. I'm just confident of it because this is a mess. Again, you know, is there going to be a broadening of the TCPA? Yes, and we're going to, obviously on TCPA world, we're going to be following this. And, you know, like I said, I think this has legs, but I don't think that this specific language is going to be adopted because it's so bad. And Pooja, you got to jump in here. I feel like I'm doing all the talking.
Well, I mean, while I don't think that maybe this specific language is going to be adopted, I do agree that the intention of this portion of the bill is that Congress does want to broaden the TCPA. And at a minimum, I think they're going to take us back to 2015, right? For folks who were in the space back in 2015, the 2015 order allowed auto dialer to include the definition of any system that had potential functionalities or future possibility of automatically dialing calls. And, you know, we were a little bit struck even back in 2015, where I think now the intention is to go back to be at least as broad as before the Facebook decision was. That's my prediction.
Well, in 2015, I was with a good-sized BPO, and I remember speaking with counsel and saying, you know, listen, you know, what do we do about calling cell phones? And when I was talking to my attorney, he said, listen, I'm talking to you on my Office PBX right now. And it was the future potential part was the part that everybody was really freaked out then because it was so vague. He's like, I wouldn't use this for telemarketing at this point in time because an argument could be made that I could upgrade my switch and now it's an ATDS. And one of the questions we've gotten even in the chat here has been around the iPhone. And I think it does bring back, and that was something that came up in 2015 was, well, what about an iPhone? Is an iPhone an ATDS? And there was a lot of discussion around, well, that does have the future potential because you could download an app and then it becomes an ATDS. So I think that 2015 observation by Pooja is very accurate. It's not even remotely hyperbolic because it's bringing in a lot of question around, you know, what does this mean and what is my risk? And the people that seem to suffer the most are the people that are trying to do the right thing. They just, you know, they guess wrong. I don't know, or they don't pick the right counsel. Take your pick. There's another part of this, though, that I think it would be good for us to focus on, and that is their definition of a text message. And I read through that several times, and I've got it up on my screen here where they say the term text message means a message consisting of text, images, sounds, or other information. Okay, what does that mean? But fine. To or from a device, and they give a list of different qualifiers. And Eric's got it up on the screen right now. And first I saw some like SMS. Okay, I got them. What if it uses RCS? But they already thought about that. That's the third sub item there. But in the to and from, as I read this, you know, first they talk about it's got a telephone number assigned to it or an N11. For those who don't know what N11 is, that's, you know, your 911s, 411s of the world, short codes. But that talks about an email address, or it's transmitted through application to person messaging. So could this arguably make an email sent from my CRM to my customer base a robocall?
Based on this reading of the definitions, the answer is yes.
Yeah. So, and you're right. I mean, we should spend some time here, right? Let's just, I know you just read it. We're gonna read it right now, really like agonizing, right? All right, so it means a message consisting of, okay, remember the definition, we're defining text message, but it consists of text, images, sounds, or other information. Okay, so anything, all right, anything that is transmitted to or from a device that is identified as the receiving or transmitting device by means of a 10-digit telephone number, N11 service code, short code telephone number, or email address, or that is transmitted through application to person messaging. Okay, so anything that is transmitted using identifiers, right? Today, currently, right now, and we've talked about this many times, the only identifier that creates TCPA is a phone number. A message has to be sent to a phone number. Now, this changes everything. This provision changes everything. Instead of a message having to go to a phone number to trigger the TCPA, now it goes to a device if that device is identified using either a phone number, email address, short code telephone number, and then this last one, application to person messaging, period, right? So in the old days, I used to tell people, hey, look, if you're using a token, if you're communicating with WhatsApp, if you're communicating, using an iPhone, which is a device, or what is it, iMessages, it's device specific as opposed to phone number specific messaging, then the TCPA wouldn't theoretically apply. But now there's no question, right? So massive change that now you're looking at the phone number, not the phone number, at the device, right, as opposed to at the phone number. And that's going to massively expand the reach of the TCPA to include anything, right, any OTT service. And then it includes short message services, MMS, RCS, right? But you're right. Saying it includes those things does not limit it to those things. And it mentions email. Now, I read this slightly differently, and this is my over-analytic lawyer brain going, as the email is the identifier, right? But it would still have to be something other than an email. But I agree with you. It's not what it says necessarily. It's very vague. It's completely unclear in terms of what is going to be covered by this. But at the broadest reading, it would include anything that is sent to a phone via any means, as long as that phone is being identified either using the email, using a phone number, using an N11 service code, short code, or separately, right? Device identified by one of those things, or any message sent using any application to person messaging, which would include any OTT, any application, any WhatsApp, anything, right? Incredibly broad, incredibly broad. The only limitation you see down here is it does not include a real-time two-way voice or video communication. So it doesn't include a call.
Right, but that's implied in the other portion of the definition under a phone call. So I guess maybe an argument could be made, and you could say, oh, don't let the lawmakers know these things that they've missed. If I miss it, the plaintiff's bar is going to catch it, and it's just going to be settled through case law. So it's better we hash this out now and know what the rules are. But a video call seems like one of the only things that could potentially be exempt from a lot of this stuff.
I mean, maybe at this point, maybe. I think, again, like I said, I know this has legs. I know that the Congress is giving this due consideration. These guys need to go back and really think about this. Again, I'm not taking a policy position here. If the policy is we want to expand the reach of the TCPA, okay. But y'all need to think about what you're trying to cover, because this is gobbledygook. It's gibberish, right? This is not in English. And somebody needs to go back and actually write what they are intending to cover. And again, I'm being agnostic here. I'm not saying this is what they should cover, what they shouldn't cover. I'm just saying whatever it is they're going to cover, they need to actually say it, because they have not said it yet. And I do not want this going in front of the courts, because it'll be a disaster for everybody.
Yeah, I guess this keeps going back to, I remember Pooja and we were talking in an event in Colorado, I think it was Contact.io last year, and we were talking about how, there's no robocall definition. We don't know what a robocall is. And I even asked you, I'm like, are you aware of a definition? Like, no, I guess be careful what you ask for, because we are definitely getting this. Now, putting a pin into this, and Pooja, maybe, this would be a good starting point for you. We've got the FCC lead gen loophole closure, but now we've got a very real definition of what a robocall is potentially. So how would this affect the new ruling for the FCC loophole?
Well, it would directly impact the FCC's ruling. If this definition, if this order gets passed, this is the law. And that law's definition is going to apply to the current order that is pending out right now. So it's going to be applicable law, short answer.
Well, because a lot of people, I think, had said, okay, so if I'm not using pre-recorded voice, if I'm not using a random or sequential dialer, some of the stuff for the FCC loophole I can get around if I'm still, using manual dialing practices or something like that. But it appears as though with this, that safe harbor, whatever you want to call it, that's completely out the window, right?
Yes.
Well, so it's basically what it does, and this is what you're driving to, Isaac, is it expands the reach of the FCC's ruling, right? Today, their ruling, again, right, there's two provisions for consent under the TCPA. There's the express written consent provision that applies to regulated technology. There's the prior express invitation or permission that applies to the DNC, right? They only modified this. But essentially what's going to happen here is currently this definition only applies, again, to regulated technology. That includes ATDS, pre-recorded artificial voice message, and of course, generative AI. But as we just looked at, regulated technology is going to change. It's going to expand under the new definition of robocall to include all these other, non-ATDS under the current definition, but potentially automated systems and even click-to-dial, even manual systems, and basically any kind of text message, right? It's going to be a massive, massive explosion in terms of what technology is regulated. And therefore, the expansion of that express written consent rule or the narrowing of it to the one-to-one is going to apply to a much broader category of technologies than it would today. And so it's very interesting, right? Like, did the FCC know that Congress was working on this? Did the FCC expect that there'd be a broader impact? And as we look now at the comment period, it's still open for small businesses to weigh in. I mean, I think, Reach has a meeting tomorrow. We're going to be talking about this because it seems like we now need to be addressing the impact of the one-to-one ruling, not even just in today. Because if you look at the ruling, the commission repeatedly says it only applies to robocalls. It only applies to robocalls. It only applies to a narrow category of calls. You can still call manually. You can still call in other ways. Well, wait a tick, to quote Austin Powers, if this new law becomes the law, dude, you're massively impacting the ability of Americans to communicate with one another. It has a huge impact on small business. It already does. Don't get me wrong. It's already massively impactful. But now you're going to take it, you're going to literally, it's going to double at least, or maybe even triple the kinds of technology that are covered by the new one-to-one rule. So, I mean, it's amazingly impactful.
Well, the timing of it's also very incredible. I'm wondering if, if Congress was already predicting folks to find their own loophole with the new one-to-one consent ruling and get around it by using different types of technology as opposed to the traditional regulated technologies, ATDS, pre-recorded calls. And the timing to get it out now is to basically say, even if you're trying to get around the one-to-one consent, we're going to stop you from doing that unless the system has substantial human intervention, whatever that means. So it seems like
requires substantial human intervention, which is crazy.
Yeah, so it seems like they're angling to push folks, if you're going to be making marketing calls without consent, to push folks to use one specific type of technology. What that one specific technology is, I don't know.
Well, you know what the good news for us is, Pooja? People are going to need a bunch of white papers, and we're pretty much the only ones qualified to give it to them. So, make it rain. No, I'm kidding. It's terrible. This is a terrible situation. Like, no one's going to know what is safe to use or what isn't safe to use. But again, this is why I keep coming back to, but let's just stay calm because this is their first draft. It's going to be an iterative process. There are going to be edits to this bill. There are, right? So what we should be wrapping our heads around is, again, according to my intel, this has legs. It doesn't mean it's necessarily going to pass, but I think we're going to have some changes here. Okay. I believe that. I believe we're going to have changes. I also believe that we're not going to have these specific changes because this is a mess. And us talking, right? This is a good opportunity for the regulators, the staffers to kind of hear from business, right? We all need to, through our channels, our trade organizations, of course, me using TCPA World, which is so well read and I love it. You guys have no idea how much traffic we drive. It's nuts. But we all just need to be using our voices and communicating through all of our various channels to any impact, any influencer, of course, any lawmaker, again, and try to do it the way I'm trying to do it, right? Don't tell them how they should do it because they're going to make their policy decisions. And maybe you've got, a really powerful brand and you can really influence policy. I don't even try to do that. All I try to do is tell them, make it make sense, guys. Just whatever you're going to do, I'm not going to tell you what to do. Whatever you're going to do, just make it logical so that we understand what the rules are, and the good businesses in this country will follow the rules. But you got to tell us what the rules are, and they have to make sense. And this stuff is gibberish. It makes no sense.
Well, somebody has asked, there's a little bit of chatter in the Q&A right now about the bill sponsor, and I think it's important to note that there are at least 5 bills that I see that appear to be tied to this. But Frank Pallone, if I'm saying his name right, is the big sponsor behind a lot of this, or at least his one of the bigger names on this. He's had a lot of success in similar bills that have affected our industry over the year. The first one that comes to mind is the Trace Act. His name is actually part of that piece of legislation. So we're not dealing with somebody who, because I remember I talked to a few people about this, and they said, oh well, bills get proposed all the time, doesn't mean they necessarily pass. And while that's very true, the gentleman that is behind a lot of this has had a lot of success in getting legislation passed for the industry. Now, I have seen some co-sponsorship from Republicans, so I know that there have been some people that have said, well, this is a single-party bill. I have seen on these bills I'm tracking that there is co-sponsorship from the other side of the aisle. So I don't know, one, if this is going to last all the way until the election season, but two, I don't know if that's really going to have any time to affect anything on this. So, and Eric, Pooja, if you guys have a different take on that, then feel free to share.
I haven't seen co-sponsorship on the Pallone robocall piece. If there is, that's news to me. I have seen co-sponsorship on the other pieces, though, which I know we're going to get to here momentarily.
And I think, and that was one of the things that people were asking about with that. A couple of questions. I just want to get to these before they go too far away. Push notifications. Would that be considered a text message and subject to the TCPA? I believe it would be, but I also believe a push notification would be something you would have given consent to, so you wouldn't be this wouldn't hurt you in that regard. But what do you guys think about that?
Yeah, I think under the definition now, for the first time plainly, because it's going to be an app to person message, right? Push notifications can be extra app or internal to the app, but they're both going to be driven to the device on the basis of the app. I don't see any way you get around it under the current definition. So they would be treated as a text message in my view.
But if you've got consent and you've got you meet all the consent requirements, it's not as big of a deal as with this. A lot of what I'm seeing in this is that there's still a lot of room for cold calling. There is still a lot of allowances to where you can try to reach new consumers that are interested in the products or whatever the services you're trying to push out there. This really would seem to require consent for pretty much any sort of marketing effort, correct?
That's the way I look at it, right? And this definition it comes back to the definition of robocall and coupled with the definition of text message is so broad. I mean, they're really just taking a swing and saying you cannot contact a phone without consent anymore. To me, it's going to be unconstitutional, but the courts are loath to strike down these things as unconstitutional. TCPA has been unconstitutional since 2011 when they started expanding it past, how it's actually written in the text. So none of us should hold our breath that the First Amendment is going to come save us, because with the current Supreme Court, the First Amendment doesn't really mean anything, which is, I'm not trying to make a political statement, but if you look at the ruling in AAPC, they don't care about the First Amendment anymore. So this is if the law is passed, right, as it is currently written, we just need to wrap our heads around the fact that, cold calling in the conventional sense of the term is likely to be going the way, the way of the dodo, unless people develop like really highly human required dialing systems that are more advanced even, I think, than what's on the market today. And that just is what it is. I guess vendors will try to develop something that gets around and people have to shift to that. But your standard, pick up the phone and call, it doesn't seem to be available to you anymore.
Now we've still got about 20 minutes left almost. We haven't even touched AI. And I think that that's very important for us to jump into, because The generative AI talk has been crazy for the last year or two. There's been a lot of legislation discussions around it. But and we've also seen a lot of technologies built, a lot of AI agents or AI systems to help create better text messages. There are people, and I personally refuse to do this, but I know there are people out there that use AI to generate marketing messages and things like that to try to help improve their communication. But there is a specific section here where they talk about disclosures and anything around pre-recorded voice or an artificially generated message. So I think it would be important to talk into that. What are they trying to get at with that? And what are some of the risks we've got with the automated generated text messages and AI agents and things of that nature?
Yeah, so I've got here on the screen, right, you see section 104, and there's going to be two mirrored provisions. One's going to modify the TCPA, one's going to modify the TSR. So under the TCPA, so the TCPA provision here, section 227 of the Communications Act, that's the TCPA. So they're going to add a new section, section K, which is going to require disclosure for robocalls using AI. If a person making a robocall, again, big broad definition of robocall, uses artificial intelligence to emulate a human being, that's interesting, right? Such person shall disclose at the beginning of the call or text message the fact that artificial intelligence is being used. And I love, by the way, that they can't even keep the lingo straight in a single sentence. They switch from robocall to call or text message. Why didn't it just say, if a person making a robocall uses artificial intelligence to emulate a human being, such person shall disclose at the beginning of the robocall the fact that artificial intelligence is being used, right? Even that small little shift, believe me, the courts are going to be like just gnawing on this, trying to figure out, is there a distinction between a call or text message as used in section K versus a definition of robocall, because they switched language there, right? But the bottom line is, this is the first ever disclosure requirement that's ever been proposed in American history. It's kind of like a historic moment, because obviously as AI continues to grow, there's going to be more regulation around AI. And this is the first disclosure requirement that's ever been proposed. So of course, the TCPA, baby, always bringing you bringing it first. So it's pretty fascinating in my view, but that's the language right there. Again, other than me kind of rubbing them for not being able to keep their lingo straight for one sentence. I mean, this is stuff like Pooja and I, like, we're lawyers. Like, we see this stuff in a brief. We're like, what are you doing? Like, anyway. But it's right there. I mean, Pooja, I don't know. Do you have thoughts on this? This looks pretty vanilla, frankly.
This one doesn't surprise me as much as other changes. I'm not surprised they moved forward with the AI disclosure. I do think, if this bill has any lines, then this portion of it will probably stay the same.
And kind of to your point earlier about not wanting to alert lawmakers, pretty serious miss here that I'm not gonna say out loud. But let's just say I'm not sure this provision would have teeth for a very basic reason that I'm not gonna say out loud.
It's funny you mentioned that, because when the ruling was about to happen, the final ruling for the lead gen loophole, you gave us some exclusive insights at our Florida summit. There is a link in the chat right now for the Arizona summit coming up in just a few weeks. The link has the $50 code embedded in it, so you can see it there. I'll bring the QR code up towards the end of this. This is the type of information we'll be going through there, so please do that. And maybe, I see a few of you have asked that Eric maybe spill the tea a little bit on his inside information. Maybe you get that out of him in Arizona. I don't know. I'm not committing for him, but might have a better chance of doing that live. There are a lot of questions about AI in the chat. I'd like to try to touch on a couple of them. What about the use of AI to generate text messages? I think we've covered that. I think that, essentially we've got to have proper disclosures in there for that. But I think there's a much more real tie to some of the artificial pre-recorded voice stuff we saw on phone calls. Now we're seeing that essentially mirrored on text messages, correct?
Yeah. I mean, this is going to apply to voice channel, text channel, any form of AI communication. There's going to be this disclosure requirement. And, today, this would not apply to a chat box on a website, right? That's going to be outside of the TCPA, probably, right? That's, I guess I can't give any hot legal takes here because God knows what's going to happen next. But as I read the bill currently, chat boxes that are AI driven on a website aren't going to be covered by this, but I guarantee you there'll be something, coming down the pipe here in a month or so that will cover that too.
Now, a lot of this seems to get into, or a lot of what we viewed the TCPA around has been from the lens of a marketer. With the AI disclosures, is that tied specifically to marketing efforts, or could that include informational messages?
So in the TSR context, which is where I kind of teed it up earlier, it's going to only apply to marketing. But in the TCPA context, it's going to apply to both informational and marketing.
Okay. A question, this is, I think, more just looking at your opinion on this is, do you think that the new definition of telephone solicitation is better placed under limitations? Because it's like all solicitations, all telephone solicitations are being labeled as bad under this, right?
Yeah, I mean, I think it is pretty telling that the word telephone solicitations, because we've already had the problem of disambiguating robocalls, right? The scam calls that are really bad, from the, maybe nuisance calls to the actually consented and informational, hey, your gate changed, so you better hustle over to gate C4 when you're at gate A5, right? All of those are called robocalls, right? And so, this big push of trying to figure out what's a good robocall versus a bad robocall. So I'm a big fan of disambiguation. This bill does the opposite, right? Not only does robocall continue to collapse everything, now they're going to take the term telephone solicitation, which had a very specific meaning, right? It's looking at unsolicited telemarketing, right? So at least we knew what it meant. And now we're going to, again, add more categories, and we're going to include fraud in the definition of telephone solicitation. So now when someone says you're a telephone solicitor, that could mean you are a telemarketer, or it could mean you are a scammer, because they are going to be including fraud within that definition. That's just terrible. And just, from a practical standpoint, what I really don't like about this as a trial lawyer is, today, if you go to trial in a TCPA case, you can have the word robocall excluded from trial because it's a loaded term, right? It's prejudicial and it has no impact in the law. So like literally you can bring a motion in limine and no mention of the phrase robocall can be permitted at trial. Tomorrow, right, when this bill passes, whenever it is, robocall can be thrown around constantly. This is a robocaller, this is a robocaller, this is a robocaller, playing on all the negative connotations of robocall without recognizing that, it could be CVS on trial for sending a prescription notification. Dear so-and-so, your prescription is ready, come pick it up. They're a robocaller, and they would be technically correct under the new definition. And it's the same thing with telephone solicitation, right? I think it's terrible that marketers are going to be painted with the same brush as true scammers who are pretending to be the IRS. It's just terrible, but that's what the bill would do.
Well, and talking about AI a little bit more, is there really a clear definition of what AI is? And before you answer that, I want to preface that with, my background is in IT. I started my professional career in IT just after the military, straight into IT, always working on computers and software, whatever. And I've seen AI mean a lot of things. So I've seen AI be something where they've just got some little mathematical formulas that say, well, if A happens, then do B, but they market it as AI. So would, what do they have, that mail merge in Word? Would that be considered AI because it's dipping into a database and automatically generating a bunch of messages to be sent out?
Don't know, right? What I do know is here in K, it's very broad. If a person making a robocall uses artificial intelligence, period, full stop, right? Is that machine learning? Is that generative? Is that, I don't, whatever the other kinds of what is it? Large language model. I don't know. I'm not a super AI geek like some of y'all are. But without a definition of AI, and there is no definition proposed here, right? You just have to imagine the courts are going to view that as broad as possible. And that's always the scary thing, right? Anytime Congress fails to define something that's highly technical and they leave it to the courts, oh man, you never know what you're going to get, ever.
Yeah, and I guess the only inclination we have on a definition of what an artificial generated voice is I think what the FCC came out with yesterday, I think on the 31st. Yeah, there was a document from Chairwoman Jessica where she said that artificial voices, AI generated voices are artificial voices under TCPA. That's it. That's the only guidance we have from the FCC on their definition of AI generated voice.
And
I love it that Pooja calls her Chairwoman Jessica, by the way. I think I love that. To be on a first name basis with these people. But I think, Isaac, before we wrap, I know we only have 10 minutes left. I think we should mention these new requirements for VoIP service providers, because again, this is huge. And this is something actually that maybe I did put Congress up to, which is to date, there's been absolutely no regulation on carriers in terms of like what the KYC requirements are, the policy requirements are, robocall mitigation. And it's not that I necessarily wanted to create limitations or requirements for carriers. It's just that the FCC and the courts are already holding them to these requirements. They're just like making up as they go along. So Congress should like say what those requirements are. And they kind of are proposing that here in this section. And again, any of you that are carriers or platforms really need to be paying attention to this. It's specific to VoIP service providers. But you'll notice, and again, we have to go quick through this. I'm not going to read the whole thing to you, but basically the FCC is being told they have to promulgate regulations that will require a VoIP service provider to verify the identity of customers, right? So it's going to be required KYC. And then proactively and continuously monitor traffic. So there's going to have to be some kind of reasonable traffic monitoring. Now, if any of you are carriers or platforms, like I don't solicit work very often. You guys know this. I just like give love, and then you hire me if you want to hire me. But this is actually a place where our firm has actually put together policies, procedures, like top to bottom, for how carriers should be addressing the new robocall mitigation rules and protecting themselves. Which is not something we talk about very often, but if you need that sort of thing, like we've got some stuff baked so we can help you, and it won't be terribly expensive. But so just everyone knows, though, there's going to be even more robust scrutiny, right? When you go as a VoIP service provider, or when you go to try to get telephony services, these various new rules are going to have to be applied by your carrier partners. So just keep that in mind.
I noticed there's a 10-day deadline, or you have 10 days to basically do something about any type of violation that you discover during this process as well. That's a very limited timeline.
Yeah, I mean, it's slightly better than the 24-hour ITG response time, but this is actually a mitigation effort, right? You've got to either stop the calls, or you've got to go back and tell the FCC why you're not going to stop the calls. But this is actually in line. The FCC has had shutdown orders. Remember, phone burner almost got shut down. So the FCC kind of dreamed up this language and has been using it in some of its enforcement. And so I think Congress just kind of borrowed that language. I agree with you. 10 days is pretty tight. It's fine for maybe the big carriers that have lots of resources, but for the small guys, I mean, that can be a real pain. Right. I mean, especially if they don't get back to you, right? So that's something else to keep in mind, guys. If you are a call center, if you're somebody that's plugging into a carrier, your carrier's got 10 days to either get with you and find out it's consented traffic, and then get back, right? So now the carrier is basically carrying your water back to the FCC and tell the FCC, hey, look, it's legit, man. They told me it was legit. If you don't respond to your carrier in 10 days, they're going to shut you off. They have to, right? So just keep that in mind. Like if a carrier reaches out to you and says, hey, we've got this complaint, we've got this issue, you better be ready very quickly to come forward with whatever consent they need. And of course, if you're buying third-party consents, good luck.
Well, I think we're running a little bit low on time here. There's a lot more to unpack with this, and I'd love to see where this develops. Obviously, if you're one of our customers and you subscribe to our regulatory guide, you'll be able to track the status of this through here. What should people be doing right now? I mean, is Reach? I know you mentioned Reach is going to have a meeting on this tomorrow. Is there a way that participants could get involved with Reach and maybe perhaps through a unified voice help drive some changes to this? Or what recommendations do you two have?
There's a lot going on right now. Go ahead, Pooja.
I think definitely, inquire about Reach if you're one of those companies that intends on following the law. We don't want, just folks joining Reach just because they want to venue to learn more about the law. That's not what REACH is formed for. But if you are really truly interested in understanding the law and, you know, meeting the REACH standards, I do encourage you to reach out to see if you want to join the membership. More importantly, I think Eric was about to say, there's a ton going on right now. This is just one proposed bill that we covered today on this call. The revocation bill, that one I've been diving deep into for the last week. That's a whole nother beast that we haven't even mentioned on this call yet. And then, of course, you still have the lead generation loophole order that is out there pending. And how all these new bills are going to come together and impact your business, we're not going to know until things get finalized. And then lastly, my recommendation is to join us in Arizona for a one-day conference where we're going to do a deep dive not only into this bill, but the other proposed bills, more in artificial intelligence, and then just tips and tricks on how to stay compliant in light of all these new changes.
Yeah.
I do have that registration link up on the screen if anybody wants to take a picture of it. Eric, go ahead.
Well, I mean, so in terms of what people should be doing, and this is it's a challenging time, right? I mean, it's tough for me to keep up with all of this, and this is all I do. So I live, eat, breathe this stuff, right? So I understand there's a lot going on, and there's, you know, people want to know, like, what really matters right now? What can I do right now? As I look at this, right, the thing that is top still on my radar screen is the public notice proceeding for small businesses that closes on February 26th, right? That is right now is tangible. It's something you can do to impact the FCC's one-to-one ruling, which, as we just saw, is going to become even more important if this legislation passes, right? So I'd encourage everyone to stay focused, even though we've got lots of going on. Focus first on the February 26th deadline, get a comment into the commission, explain why your small business or small businesses generally will be impacted in a detrimental way by the one-to-one ruling, and offer other solutions if you have any, okay? So that's the first thing you should be thinking about. The second thing I think in terms of a priority right now is the revocation ruling that Pooja was just talking about. That ruling changes everything, and it changes everything right now. It's going to be effective in 60 days, okay? So, you know, the one-to-one implementation period, right, is going to be in January 2025. You got to keep an eye on that. But the next deadline is like March 26th, right? And that's the revocation deadline for the new FCC ruling. Again, we've not provided many services on that or coverage on that. It is on TCPA World. We're going to unpackage that more next week as time goes on. Again, critical information, really valuable to be in the summit in Arizona, because we're going to be breaking that down in detail, and you really need to know about it by ahead of that March deadline. And then again, this Pallone bill, you know, these changes to the TCPA we just talked through, critically important, but still kind of hypothetical, right? They're not real, they're not tangible yet. So to me, that is less important from an operationalization standpoint, but it is a driver, you know, as we're all saying, to continue to come to REACH if you're a good company. If you're a good company, come to REACH. Like, we are the trade organization now that is advocating, that is pushing hard. Put your chips in, man. It's $1,500. Support the cause. You know, we're going to be meeting tomorrow. We're going to figure out how we're going to lobby, and we're going to help to effectuate change here. But beyond that, right, just be socializing, be talking about this. The biggest problem with the one-to-one ruling, you all remember this, right, is I warned everyone a year before it was coming, because I always know. Maybe not always, but I usually know. And just the discussion was, Eric is wrong, right? Oh, it's not going to happen. They're not going to do it. It's not true, blah, 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 blah. Guys, like, this is real. We can affect change. We have to talk about it, socialize, come up with solutions, share our views publicly, share our views on LinkedIn. People read this stuff. And by people, I do mean staffers. I mean Congress members. I mean people that have influence. And again, you know, the more you take TCPA World content and spread it, the more you create your own content and spread it, the more you're talking about it on your podcasts and your YouTube channels, it gets into the ears of the people that it matters and who can influence the change. And I really encourage all of you to use your voices and speak up. And you will be surprised that people do listen. I mean, I'm an example, right? I was just a little blogger, you know, a few years ago, and now I've got a pretty good platform, and you all can do the same thing.
Well, and, you know, speaking of spreading the word, if you go to our website, dnc.com, there's a section for webinars. This will be posted, I would guess, within the next day or two. I believe it's going to be posted through TCPA World as well in the coming days. So, you know, make sure you're getting the word out there, raising awareness. You know, any comments we've made about, not liking the law or pushback is going to be done from a lens of trying to help educate the people behind these bills and help them understand how this impacts the business. I think some of the reversal we saw in Florida may be because they realized that it was a little heavy-handed, and maybe it wasn't even completely intentional with what they intended to do there. But ultimately, when the law is passed, it's our responsibility to educate you on that and help you follow it. So that's the purpose we serve. That's the purpose that Reach is there for. So please visit our website to find out more. Please come to our summit to get more educational information. And as always, we're going to try to continue to bring you guys the latest information. And with that, we're at our hour. So thank you, everybody, for your time. Eric and Pooja, as always, it's a pleasure to have you, and thank you. I'm looking forward to seeing you in Arizona, and be looking to hear from us all soon with more updates. Have a great day, everybody.
Thanks, Ron. Bye-bye.
Bye.